Okay, so we should be recording now, but I don't see that.
Yes, it is.
It is.
It
Okay,
is.
great. Okay, so it's 9 a.m. So welcome everybody. We have 44 people on the call now. It's just right at 45 now. So I think we'll have several more as we get started. I'm Marianne Krasny. I'm on the faculty in the Department of Natural Resources and the Environment at Cornell University with the Civic Ecology Lab. And I'm your, I guess, primary instructor for this course. And also we have our Chinese lead instructor, Jin Yu, and he goes by the English name of Fish. And then several other people who are helping us, like Amy Daniel, who's our tech person. So I just really excited about our first webinar, but I wanted to spend a couple of minutes with a few course details. So I'm going to share my screen. Okay, so welcome to Climate Advocacy, Making Policy Change. We know a lot of you are return students from our other courses. And then of course we have some new students, so we're very excited. And as of this morning, we had 850 people signed up from over 50 countries. And we are still accepting new course participants until Friday, May 24th at midnight. So please share the course announcement, just civicecology.org, and then go to Advocacy with friends and family. And maybe we'll have a few more participants from around the world by the end of the week. We also have 2 country or language groups so far. And what this means is that we have a leader for these groups who's a native speaker, and they will be holding real-time online and also offer support asynchronously through various social media groups. And so we have Chinese language, which Fish is leading, and I think you're going to be having a meeting today at 10 o'clock New York time. So after this webinar ends for a half hour, you can stay on this call to review the material in Chinese. We also have Dr. Zara Golshani, who will be leading a Persian language groups for our Iranian and Afghan students. And I'll be sending that information out to you on how to contact Dr. Golshani and join her group. We have lots of Nigerians, Ghanaians, and people from other African countries. If anybody wants to start an African group or a country group for people in a specific country in Africa, please contact us through our WhatsApp group or through the Civic Ecology at cornell.edu email, and we can share the information with our other students. We don't give out student names, but we'll share the information so that students can join if they want. And don't forget about tomorrow, office hours. We will be having an informal discussion at the same time. And yeah, come with your questions, ideas, whatever. It's a great time to share, and I'll be leading that. So with that, I'd like to introduce today's speaker, Dr. Joana Setzer. And she will be talking today about climate litigation. So I'm super excited to have Joana here because climate litigation is just such a fascinating topic to me. And she is a world expert on this topic. I saw today there was earlier this week, a new suit coming out. We saw the Swiss suit from women, which was viewed favorably a couple of weeks ago. So I won't talk anymore about climate litigation because I don't know a lot, but I will give you a brief introduction to Joana Setzer, who's an associate professor, professorial research fellow at the Grantham Research Institute on Climate Change and the Environment at the London School of Economics and Political Science. Her main areas of expertise are climate litigation and global environmental governance. Since 2013, Dr. Setzer has been involved, and since 2020, she has been leading the Grantham Research Institute's Climate Change Laws of the World project, the most comprehensive global resource on climate policy and legislation. Dr. Setzer is also a contributing author for the IPCC Sixth Assessment Review, and she's co-chair of the Climate Accountability Working Group of the Climate Social Science Network. So with that, I'm going to stop sharing. And let me just focus on that for a second. Sorry, guys. I already stopped sharing. So it's time for Dr. Setzer to share. And
Thank you so
you
much.
can please keep yourself muted for while Dr. Setzer is speaking. After 20 minutes, you will be able to unmute yourself and ask some questions. Try to keep them brief so everybody who wants to gets a chance. And then I think you'll have some more time after that, right? Then you'll go back to some more presentation after 20 minutes. Also, feel free to write your questions in the chat and I'll keep track of them and ask Dr. Setzer for those of you who don't feel comfortable unmuting.
现在还不一定。
Don't forget to keep yourself muted, guys. Sunny, that's you. Okay. Do not unmute yourself until we ask for questions. Okay, ready to go. So do you want to share?
Great. Yeah. So first, let me say hello, everyone. I have to say this morning when I thought, oh, another webinar, why are we still doing these? What's the point in having a webinar? I don't know. If I was it was raining and I was grumpy in London. And now I'm seeing this group and people, some of the colleagues already introduced themselves, and I'm seeing here in the chat box how people come from all around the world, and it is wonderful. It is really, it reminded me why we do webinars, and really congratulations, Marianne, on bringing so many participants from so many countries that wouldn't have access to this otherwise. So it was a very good reminder of how wonderful Zoom can be, just for bringing people from Nigeria and China and Europe and US all at once. So thank you again. Hello, everyone. Nice to be here. As Marianne said, I want to talk to you today about climate change litigation. So I have a few slides, which I'm sure will be then made available to you after. The way I wanted to do this presentation is that I wanted to, sorry, is it working all right? Yeah, no, there's something.
Yeah,
sorry.
we can see.
Yeah, good. So the way I wanted to do this is I want to start giving you an overview of what is climate change litigation, what is happening in the world. Then I will stop and ask questions. So any questions you have, keep them in mind, and very soon we'll be able to address. And then I do the other half and more questions at the end, as Marianne said. So hoping to keep this interesting, accessible, but also for those who already know a little about climate litigation, that it's still interesting. This work that I do is work that is part of a larger project at the Grantham Research Institute at the London School of Economics. So we have two main areas that we work on, that I have been leading. One is climate change legislation, and here I take the opportunity to invite you to look at our database. This is the world's largest, most comprehensive database of climate laws and policies. So every act of the executive and legislative of every country in the world that is climate related should be here in this database, which now uses AI and machine learning. So you can find really laws that you wouldn't imagine from countries you'd never imagine had something on displacement or just transition or transportation, targets, and download all in the spreadsheet. So laws and policies in our database, Climate Laws of the World. And then also we do this work monitoring, analyzing, understanding climate change litigation. Every year in June, so next month, we publish a report that is this one that you can see in different colors from the last few years, where we analyze the trends in climate litigation. And so much has been happening recently that really it's become a very useful tool for you to get a sense of what happened in this past year and what might be future trends. So if I can also already invite you to the launch of the 2024 report, which is happening on the 27th of June. For those in London, you are very welcome to come in person, but for all of you around the world, you can also join us online. It will be a hybrid event on the 27th, and you can already register on the Grantham portal. I can add the link here if that helps. So what I'm presenting today is very much based on our ongoing work on climate change litigation trends. And for those who are not familiar with what this is, I want to give you some concepts and definition and how we go about. So the cases that you might heard and that we will discuss today are those that are usually brought by NGOs and individuals against those who are most responsible for the problem or for the solution or both of addressing this crisis. So we're talking about governments and we're talking about corporations. And this litigation is not just any type of, there's a very heterogeneous group, but the one that you will have heard is this strategic litigation, similar to racial discrimination, human rights, LGBTQ, other types of strategic litigation that has been and is still brought to change behavior, to change policy. There's that, but there's also cases that are more your usually, bread and butter of clarifying, challenging any specific regulation. So these cases have to have explicitly the word climate change in the filings, in the decision. Why is this important? And for colleagues out there, for instance, in the African continent or in Latin America, there are many cases that are brought to court that are important for climate change because they're dealing with power plants or deforestation that simply don't have the word climate and therefore are not usually considered as climate cases. And this is a limitation, but it's just the way it is because otherwise we just can't cover everything. So we take this narrow approach and we consider climate litigation the cases that are brought before judicial and quasi-judicial, so administrative bodies and other investigatory bodies that have material issues of climate change science, policy, or law. What do we do with these cases? We look at them and we try to first look who is being targeted, against who this case is brought. So governments or corporations, usually these are the ones. Who is bringing the case? And then there's a wide diversity. Who is bringing climate litigation? Well, individuals, NGOs, but also political parties. Governments are bringing cases. And so this is quite a broader group of actors. Where is the case being filed? Is it in the domestic court? Is it in an international court? And then we do some more subjective assessment, and we try to understand, for instance, if this is a case that is strategic, if it's aligned, and if it's not aligned. So let me now go to some examples, so all of this hopefully will make sense. So what we're seeing is that increasingly, climate change, courts are being asked to address climate change issues. I have here extracts of the two most recent important decisions. So one by the Supreme Court of India and the other one by the European Court of Human Rights. And both you have here in bold the same or very similar understanding that, that there are cases that deal with climate and that these are topics that the courts now have to assess. For many years, the courts were saying, no, this is complicated. This is science. This is stuff for governments and policymakers. That's changed. Now courts know they have a role in looking into these cases that are brought. So, for instance, the European Court said the task of the judiciary is to ensure the necessary oversight of compliance with legal requirements. And the Supreme Court of India said also that courts have been confronted with challenging task of adjudicating cases where significant issues related to climate change are at stake. The topics of environmental degradation, pollution, industries, and infrastructure projects have long formed the corpus of cases before courts across countries. Of late, however, is increasing number of cases to do with climate change in one or other way. So you have courts accepting that they should be doing this. And the Indian case is the first explicit climate case that reached that Supreme Court in India. So courts are trying to do two things: to take up this role, but at the same time to balance the different powers. So that's clear in the European case, where they say, yes, there is an oversight here, but still we know, of course, that legislators and policymakers are doing the bulk of the work. So what is it that we're talking about? How many cases, more or less? In our reports, you will see these graphs that we update every year. This is not really everything, because these are really the cases that get to our knowledge via the Sabin Center with collaboration of other partners. But you can see here it's grown significantly, especially in the last few years. So our last report had around 2,300. Now we are close to 2,700 cases around the world. Over 2/3 or around 2/3 in the US. So still very US phenomena, but spreading around the world. And you see here that 2021 might have been the peak, but we don't quite know, because there's an issue with data collection. So what we know is that these cases are growing not only in number, but in importance and in geography. So when we talk about geography, you have here this map of the world, and you can see what I described in terms of the US being this dark blue, where most cases are. Second, Australia, and then spreading around the world, with Latin America having become a more important region for climate litigation, and some few cases in Africa, also quite recent, Europe, and around Asia. So it's basically taken over most countries already, or most regions, definitely not countries. So we have already at least 51 countries from across the world. And we also have cases before international courts. So if you read the news yesterday, and I will talk about this case, not yet, very soon, there was a new case that has been decided, or that an international court gave its opinion. I'll talk to you about that. So we have over 50 cases also before international and regional bodies. So there's so many cases that we need to find ways to make sense of this body of cases. And this is what we try to do in our work, in the report and other work. So the first point that I made briefly in the first slide is that litigation, as climate litigation, as any type of litigation, can come from every direction. So you can have cases that are aligned with climate objectives. We call these climate aligned. But also on the other side, you can have cases that are non-aligned. So cases that are trying to weaken climate efforts, regulation, ambition. So you have these two kind of black and white extreme points, but not everything is very straightforward, right? So you have something in the middle, a gray zone that we have currently called just transition litigation, or that, it's just basically the non-obvious cases where you have, for instance, groups that are already vulnerable, that are affected by climate policies. So let's say indigenous communities that have their land taken for solar projects or wind projects, and they are challenging those projects, which are projects that are in principle good to deliver the targets that we need, but that are affecting their rights. So you have different rights here being opposed: human rights of already vulnerable people and climate policies. And this is part of the complex picture that is addressing climate change, and often this is thought in terms of just transition. So we have named these types of cases just transition. So this gives you an idea of the big spectrum of cases, from aligned to non-aligned, and this area in the middle. And what I want to do in the next part is to look at examples of such cases. Before, let me already stop and ask if anyone has questions that are about this overview that I gave you in terms of the big numbers and how we select the cases, and that there are cases that are aligned and non-aligned. So I can't see, let me see if I can bring back here the the box.
Yeah, there was one question in the chat, and that was, what does SLAPP mean?
Sorry, SLAPP suits. Okay, yes. Okay, so these are cases that are brought against individuals. So for instance, you have a few examples now of even oil companies or interest groups that are filing cases against individuals who are either protesters or scientists. And these SLAPP suits that stand for Strategic Lawsuit Against Public Participation are basically understood as litigation that tries to stop those individuals and groups from protesting, from participating, from stating their opinion. So this is one of the examples of non-aligned, because they try to, with one or more cases, show to individuals and groups that they shouldn't be advocating, they shouldn't be litigating, they shouldn't be publishing their opinions. So especially in the US, we've seen in this last year, and I can talk to you a little about that, an increase in the use of litigation to stop public participation and kind of silence even shareholders from asking for more climate ambition.
Great. Okay. We have one person who would like to introduce themselves, unmute themselves, excuse me, and ask a question.
Sure.
All right, thank you so much. I want to ask my question about this diverse use of strategic litigation. So I saw that for the climate aligned, the government framework is about 80 plus, while personal responsibility is 8. I saw that Nigeria has about 1 to 10 cases of climate litigation. Now, my question is, as an individual, as a forester, and as a climate change advocate, we barely see the effects when it comes to climate change advocacy. Now, is there an international organization where those cases were reported to? And 2, can we also have it the other way around, that what can we do as personal responsibility? How can we heighten or increase the number so that, of course, the governments are seemingly not most of the governments are not yielding to our pleas, to our demands. So how do we go about that? Because right now in Nigeria, some part of Nigeria, the southwestern, we experience about 34 degrees Celsius. So is that hot? How can we go about all of these things as personal responsibilities? And what organization do you report to?
Excellent. Thanks for your question. So let me explain what we mean by personal responsibility cases. So as I said, the majority of cases are filed against governments. And when we say governments, it's like it's a case filed by an NGO against the state of the Netherlands, or the state of the Federal Republic of Germany, Federal Republic of Brazil. So it's a case brought against the government in general, or against a company. So against Shell, against Exxon, against a soy producer. So more recently, we started seeing cases that are brought against individuals. So instead of a case against Shell, or in addition to the case against Shell, we saw cases brought against the board of directors of Shell. So then you have a list of individuals that are directors of that company, that the case will say these individuals had fiduciary duties to act differently, and they didn't. And this is why we're bringing this claim against those individuals. So John Smith, whatever, Mary, whatever. And so this is where we talk about the personal responsibility cases against the person of the president or the person of the minister of environment that has withdrawn or not provided the financial mechanisms for climate policy. So there are several examples now that we see this personal responsibility emerging, and these are numbers from last year. So this is still, we will have more this year, but I think that hopefully explains the difference between cases against governments and against corporates versus cases that have the individuals involved. Now, in Nigeria, there are a few climate cases that have already been filed, and you can find all of these in the Sabin Center database of climate litigation. So now I just looked here, we have 3 cases in Nigeria, known climate cases in Nigeria, which are one again regarding Shell, one it's the Center for Oil Pollution versus the government, and then the other one is also against Shell. Again, the point I made in the beginning, there are many environmental cases in Nigeria. There are many other cases that would be relevant for climate, but because they didn't have an explicit discussion on climate change, they are not classified as climate cases. But I have a colleague, Kim Bauer, who edited a whole book about climate litigation in the African continent, where different scholars write about their countries and bring other cases that are not officially in the database but are relevant to climate. So if you're interested, I can send you the Nigerian chapter, for instance.
That's great. So we have a couple, we have one question was about stranded assets. I think it might have been related to SLAP because it came a while back. And then we have Alan, who would like to unmute herself and ask a question.
Hello. I hope it's all right to ask. Can
Yeah,
I be
that's
heard?
great. Yeah, we hear
Okay.
you. Can you tell us where you're from?
Hello, I'm Alan. I'm from the Philippines, in Southeast Asia. My question is mainly about, since you have given a diverse or a list of the diverse use of strategic litigation, I wanted to ask the speaker, what do you think is the most effective litigation that has been passed maybe in developing countries or developed countries? Because sometimes I have had observations where there are litigations or there are environmental laws and policies that are being passed, but sometimes they are being passed just to conform to, let's say, the current standards of being climate aware, or that um there are times that sometimes laws just have to be passed on for just to save face, if that's okay to say. But yes, from your personal, or maybe from your research or from your observations, what do you think is the most effective environmental policy or type of strategic litigation that has been passed is quite effective when put into practice? Thank you.
Thank you. So let me start with the stranded assets. So I see people asking, maybe the climate aligned ones are more obvious. And I agree, the climate aligned are less. And the stranded assets ones are very interesting cases, which I wouldn't be looking in the second part. So I think it's good that I answer to this question now. And we're talking about cases that are brought usually by companies against governments, when governments regulate in a way that means, for instance, phase out coal, right? A government decides to phase out coal, and companies that have permits to operate coal units, they will say, well, I have a permit, I have a coal power plant, and now I can't do this, or I won't be able to do this because the regulation has changed. That coal power plant becomes a stranded asset. And so what the company is doing, it's seeking compensation from the government, saying that they have no fault, nothing to do with the fact that the regulation has changed, that they have still the right to operate, and if they're not operating, they want to be compensated. And this often takes place in international tribunals through, international arbitration courts, through what we called ISDS, Investors State Dispute Resolution Mechanisms. And these amount to billions of dollars in claims by companies who are seeking compensation from governments. So this is where you see that it's not aligned, and that it's using that idea of I have now a stranded asset as the reason for the claim. Now, in terms of the question of what is most effective, I'll talk to you about some of the cases that have been more successful. So I'll leave that one for the second part. And if you don't mind, because it's very much part of what we speak in this second part of the talk. And I ask Wouter Gregorio if he wants to ask his question. I see he has his hand up.
Yes, thank you so much for the wonderful presentation, Doctor. We do believe and know that climate change is really a phenomenon that is affecting the whole world. But my main concern is with the vulnerable communities. My question is, what can be done in order to disclose the cases hidden in affecting communities? Because believe me, in Africa, you talked about Nigeria, and there are other countries that really are being affected by climate change, but the cases are hiding. So what can we do in order to address those communities? Because we are facing challenges like economy or the environment. So vulnerable communities are being affected in Africa, and some of these communities, some of these cases are not known, are not published. So what can we do in order to address these communities?
Yes. So thank you, Wouter. If it's true that there is a general imbalance in the world in terms of how much attention is given to cases in the north. And just to give you an example, very often you see in the media, in the English media, some news about cases that I'll talk to you more about, brought by cities and states in the US. So think California, San Francisco, Oakland, all these cities and states in the US that are suing oil companies and asking the oil companies to pay compensation for costs that the city will have to improve protection to sea level rise and other investments that are needed to protect the population from the already existing impacts of climate change. So you would think, so two issues there. First, do you really think that California needs money from oil companies if you compare to Angola to build walls to protect the city from sea level rise? That it's a really big question. Why is it California getting the money and not Angola? and secondly, that these cases get so much coverage, and academics write about it, and journalists write about it, and very few people write about what's happening in Angola. So there are two big problems there that you very clearly brought. And I would say to the first one, there is obviously a need to think about loss and damage in a global way. It's very difficult that the international negotiations have been so slow in making the fund for loss and damage operate, and to have we are still far from seeing how that fund will have the money and give the money away. But clearly, it shouldn't be down to individual cases, because you would see the situation where California is getting a lot of money from Exxon and Angola is getting nothing because they didn't bring the lawsuit. So this is one. I think there is some benefit of bringing individual cases, and we'll talk about those, but we still need more global solutions and funding to pay, especially in vulnerable countries and communities. And then secondly, it's something about making those cases, if they exist, known. So if there is any case in Angola that you know of and that is not in the database, you can write an email and it will be added to the database. Once it's there, there's a much better chance that we will be writing about it, that there will be, the journalists also use a lot this database, so there's a good chance that they will be known. We have researchers and colleagues in several countries who are finding these cases and sending, but it's not perfect, and especially it is limited in countries that are not English speaking. So definitely it is important to have, if you come across, if you know something, to at least let us know about those cases, and also in these countries for people to write and make these more visible.
Thank you.
Pleasure. Marianne, have I answered questions? I was now thinking of moving on to some good examples to illustrate what we're talking about.
Sure. Yeah, I didn't see any more questions. The only thing I see is that Jaren Ellis posted just a link to a South African communities versus Shell. High court victories show that cultural beliefs and practices count in climate cases. So it's your choice if you want to comment on that or move on to your next slide.
Let me move on, and I will look into these cases now as we go into some examples. So I said that I wanted to focus on some of those key types of cases that we've identified. And one of the most important types of cases of these recent years are cases that are brought against governments that are seeking either more ambition or the implementation of existing legislation. These cases tend to be quite broad in that they they're not dealing with just, say, one coal power plant, as I gave the example. They're talking about whole policies, whole sectors, reducing emissions across the board for many countries. And this all started becoming big, at least, with one case that I want to talk to you about briefly, which is called the Urgenda case. The Urgenda case is a case filed by by an NGO and a group of citizens from the Netherlands against the government. So you have this Dutch NGO telling the government that the Netherlands is a rich country, that the science indicates that more reductions need to be more ambitious, and that the existing legislation was not ambitious enough. So the Urgenda case is the first case that got a court to say, government, you're not doing enough. Can you step up and do more? So the decision on the Urgenda case was given in 2015 by a district court. And you can see here in this graph what happens after 2015 in terms of the number of cases that are seeking more ambition and implementation around the world. So the Urgenda case is initially decided by a district court. The government says appeals of the case, of the decision, and with several arguments. But for instance, it brings one of the current common arguments, which is so-called drop in the ocean. So the Netherlands says, well, you know, we're a small country. We only contribute to a tiny bit of the problem. Why should we be then spending more money to become more ambitious if China and the US are not doing their part? So classic response to the request to be more ambitious. And the court says, it doesn't matter. What matters is that you have a duty of care to protect Dutch citizens. So if the US and China are not doing their part, it's nothing we can do about, but as a Dutch court, we can tell the Dutch government to do better, and the Dutch government should do better. The case goes all the way to the Supreme Court, and it becomes a real human rights case. And this is an important part of this story, because in the recent years, many climate change cases became also human rights cases. The two areas came together in saying that protecting climate is protecting human rights. So the court says it is a matter of protecting human rights that are stated in the European Convention of Human Rights, and therefore the decision is right. The government has to adequate its policies to respond better to climate change. What follows is that so the government loses. It has to invest in renewables. It has to invest in energy efficiency. It has to phase out coal in the Netherlands, and this is all happening. Many other countries, in many other countries, NGOs pay attention at this case and say, well, you know, my government's also not doing great. Can I bring a version of the agenda case in my country? Can I sue my government? And in many countries, the answer was yes. So we see in Germany, we see in Peru, we see in South Korea, we see in the US, we see all around the world examples of litigation where young people usually, but not only, in the Swiss case, old people, old women in that particular case, are suing their governments for not doing enough. Many of these cases get all the way to the Supreme Court, and in our last count, out of 9 cases, but this is already outdated, but anyway, I'll give you that figure. Out of 9 cases, 7 were decided favorably to the NGOs, to the individuals that brought the cases. So you can see, and this responds to the question of success, these cases against governments have been quite successful because they're very big cases. They have they're high profile, they are cases that are quite political also, and in the majority, the courts, the highest courts of countries, have decided in favor. In the Swiss case, which you might have read about, and if not, just look and you'll see lots of media around that. It's a case that was lost in Switzerland. So the Swiss Supreme Court said, no, the government is doing whatever it has to do, and we are not going to talk about this in court. The elderly ladies file a case before the European Court of Human Rights. The case before the European Court of Human Rights was decided last month. It's the first time that the court decided on a climate case, and what the court decided is that first, yes, this is a matter of human rights. Second, yes, the government is not doing enough. Thirdly, the government has to legislate in a way that has more targets, that has more monitoring, and that is consistent with the best available science. So I think these examples give you an idea of the diversity of countries that have been already seen this type of litigation, that these cases have been successful, and that now we have this strong human rights angle to many of these cases. Of course, the human rights angle is not always very like the same in countries. So countries that have a stronger tradition of dealing with human rights cases tend to be more favorable. And here I have an example of the Supreme Court of Brazil that decided its first climate case, saying the Paris Agreement is not just a climate treaty, it's a human rights treaty. The government was not doing enough, and it decides in favor of, in that case, a political party, a group of political parties that filed the case against the government. In the UK, however, courts are more cautious. Human rights litigation and climate litigation doesn't get that level of acceptance by the court. So just last week, there was a decision by the Supreme Court, which tends to be on procedural matters, not on the merit, as we see in the European court or in the Brazilian court. So these are the cases before domestic courts, but I mentioned that there are also cases before international courts. The case that was decided yesterday is an advisory opinion. It's the one in the middle here of this slide. It's an advisory opinion that has been requested by a group of small island states. It's an organization, it's the Commission of Small Island States, COSIS. And in 2022, they requested an advisory opinion from the International Tribunal for the Law of the Sea, ITLOS. And what they asked was whether states have an obligation to protect and preserve, and this is where it becomes more narrow, the marine environment in relation to climate change. So the request is submitted in 2022, and yesterday the court made public the advisory opinion. So I listened through the whole reading of by the judges, and it's been a very successful case. We're still analyzing the more than 100 pages decision, but basically the court said that states have an obligation to preserve the marine environment. And what I found very important also is that it says states have the obligation of reparation. So if a marine environment is being degraded, impacted by climate change and pollution, a state will have to put money and restore that environment. So this was the first of 3 advisory opinions. The other one is, the other 2 are ongoing. One is brought before the Inter-American Court of Human Rights. And the third one is brought before the highest court in the world, the International Court of Justice, the ICJ. In all of these 3 advisory opinions, what has been also fascinating is that the 3 broke world records in terms of number of submissions made to the court. So usually you have these advisory opinions or cases before international courts where a few interest parties, depends on what is allowed in each court, but a few interest parties will be allowed or will make submissions. All 3 courts had record-breaking number of submissions, with hundreds of interest parties making submissions and saying that basically different angles of how this is an important matter, how the science is robust, and how states have obligations to respect of climate change. So from international courts, from cases in domestic courts against governments and international courts against governments, I want now in these last minutes to talk to you about cases against corporations, because these are the minority of cases, but they are super interesting and important. A few of the most interesting ones deal with compensation. So these are the ones that you would think, if you have a environmental law understanding, the idea that you polluted, you have to pay. So Shell, Exxon, BP polluted, they have to pay. And if you haven't heard about it, the most interesting case, I think, is still the Saul Luciano Liuya versus RWE. This is a photo here of this gentleman, a farmer, mountain guide in Peru, who brings a case against RWE, the giant energy company in Germany. So the case is filed in Germany, and it says, my village, which is just below this glacier, is at risk because of climate change. The glacier is melting, and once it melts, it's going to flood and destroy my village. So I want RWE to pay to protect the village and build walls that will protect the village and avoid this disaster happening. So this is ongoing, similarly to several of the cases that I mentioned of the cities and states against the companies in the US. But it's not the only type of case. There are cases that are saying, well, really, it doesn't matter that in the past these companies have been emitting. It doesn't matter, like, we're not asking for compensation for any damages. What we want is that there is an understanding that the science is there and that these companies cannot continue business as usual. So the photo there, this man holding a piece of paper and celebrating, is a photo of the Shell case. It's a case brought by a Dutch NGO against Shell. And remember everything I told you about the agenda case. There's a duty of care to protect Dutch citizens. That finding, that ruling was then extended in a certain way to Shell. And it says Shell has a duty of care. It shouldn't be doing as it's been doing. It should align with the Paris Agreement and reduce its emissions. So they won in the District Court of The Hague. That's the photo. The case is under appeal, but that was the first time that a company was told to reduce its emissions into the future, let's say. And then there are other cases that have been being brought not against the emitters themselves, but against those that finance activities that result in emissions. So the photo there of a case against BNP Paribas, the bank, is an example of that. The last type of case, it's actually one that has grown significantly, hundreds of cases of climate washing. I think everyone is familiar with the idea of greenwashing. Climate washing is basically greenwashing on climate grounds, and we've seen a huge increase in this type of cases, which has resulted in what we see in this slide as a diversity of companies involved. So it's not just the emitters. You have cases brought against Ryanair and American Airlines and car manufacturers and fashion brands and every company that has made, not every, but all cases against companies that have made statements about their net zero, their climate alignment, and that cannot be proven. Now, before I finish and open for questions, I said, yes, there are the more complicated just transition cases and also cases that we see that are, as we increase the level of investment in climate solutions, so say in carbon markets, it's a very strong example, there's also a risk of increased corruption taking place or integrity issues. So we have published this report last year where we look at this type of increase in corruption and integrity risks that are a result of the solutions, of the investments made into climate action. And really now, just to finish, I want to end with this idea of the so what. Well, climate litigation has now been understood by many, including the IPCC, the Intergovernmental Panel on Climate Change, as one of the tools to address climate change. So you have many tools, you have technology, you have legislation, you have markets, but law and litigation in particular are also considered as one of the tools. So they can affect the outcome and ambition of climate governance. We see that this is very dependent on how you understand the success of the case, of course, but that sometimes even a case that has been not successful can help shaping narratives and changing behaviors. So if you're interested in this type of analysis, I've published this paper with a friend, and there are other materials that will tell you examples of when it's not all about winning in court. There are other situations where that behavior change, that policy change takes place even without the victory in court or while the case is being decided. The outcomes so far are hard to tell. There are cases that win, there are cases that are lost, there are cases that are kind of neutral. So it is really still very much about the power of climate litigation has been on the storytelling, on the shaping narratives, and impacts that can be even quantified. So I have a paper with colleagues where we try to quantify the impact of filing a case in firm value. So what we find is that filing a case and a decision in a case results in a drop in company share prices. And this for companies, it means a big deal. So you can see that the litigation, even the filing of a case can already result in a loss in reputation and indeed in share prices for companies. So I stop here, and I hope we have more questions and time to discuss. We have still, a few minutes.
Okay, great. I have some questions here. And nobody said they wanted to unmute themselves. So if you all can keep muted, because we don't have time for everyone. No, we actually have 7 minutes, Joanna. But
I'll be very
ask the
quick.
questions I have and then that were in the chat, and then maybe somebody, if we still have time. So first is this is from Patricia, and she asked, what measures can be taken in the climate litigation at the grassroots level?
So grassroots level is a level that we've seen a lot of litigation. What I think is very important is that these cases really they involve the community in a way that it's not just about the result. So there is a whole literature and efforts on climate law in community law. The name escaped, but communities being part of the litigation and being part also of the moment where you have a decision and you have to implement that decision. So community lawyering is this term that is being used, and many NGOs, for instance, have been making a real effort to involve communities broadly in a case, and the case becomes not just the case of the lawyer who filed the case, but the whole community can use the case as an opportunity to discuss what they want to see from governments, what are their main concerns. So to make the case bigger than just the actual piece of paper that is filed before the court. If you want, we mentioned some of this literature and some examples in our report.
Great, thank you. Jaren asks, are there statistics on the average cost of climate cases?
Unfortunately, no, there's not such, it's often not public how much companies are spending in lawyers. There's a fascinating case, however, that is brought by an oil company against its insurance company, because these companies have insurance to pay for litigation, right? It's not that they're paying themselves, they have an insurance, and the insurance will cover those costs. It happened that the insurance company didn't want to pay the costs of the litigation, so the case ends up in court, and the oil company is saying, it's going, even if we win this case, we'll spend I think the number is at least $800,000, so kind of $1 million just basically to defend this first part of the case. So we're talking about millions of dollars just to defend. If they lose, then those millions become many millions. So these numbers are not public, but we're talking about millions, potentially many millions of dollars in costs plus fees, plus if you lose and have to compensate.
Okay, great, thank you. Zhao Tong, and then also Zainab, sorry for the pronunciation, are interested in climate washing. One of the questioners didn't really quite understand it, and the other now understands it, but was wondering if you could give an example.
Sure. So the climate washing cases have grown significantly. I'll tell you the first one, and then some of the most recent ones. So the first climate washing case was a case brought by a British NGO called Client Earth against BP. BP is the UK's oil company, British Petroleum. So BP puts all this advertisement campaign out there in tubes, in metro stations, in the streets, and they say, we are green company, we invest in renewables, we are a renewable company. It's a whole branding exercise to say how green they are. Now, if you show my children this advertisement and say, what do you think of this oil company that is very green? My children would say, bit weird, isn't it? So that's the kind of thing. It doesn't take a lot of evidence, science, or brain to say there's something not quite right. So what happens is Client Earth files a case and says, well, BP, you're saying you're a green company and you invest heavily in renewables. I have here your books and you invest 0.01% in renewables. You can't put this outdoor saying that you invest heavily. 0.01% is not investing heavily. What happens? Next day, British Petroleum puts all the advertisement down, the campaign disappears, right? So that was a very successful, it didn't even go to court. It was before a focal point of the OECD. They didn't even get to the end because BP quickly realized that they should just put the advertisement campaign out. Now, what follows is many cases like that. So we have, for instance, KLM being sued for their offsetting options. So KLM says we are carbon neutral, we are offsetting, and a case now before court says, well, you're relying on technology that doesn't exist and you're not carbon neutral. Greenwashing, climate washing. And even cases against companies that you wouldn't expect that are kind of greener, but are also using these claims.
So thank you so much, Joanna. We really only have 1 minute left, but Rong Tao really wants to unmute themselves and ask a question. Rong Tao, are you still able to unmute yourself? And can you ask your question like super, super fast?
Yeah, thank you. Hi from Melbourne, Australia. I've got a wild guess. Could we possibly have a international climate court, just like ICC? Because you've mentioned like personal responsibility. That reminds me of ICC is prosecuting those who are personally responsible for atrocities. So could we possibly have a court like this in the future relating to the climate governance? Thanks.
I think it's a good question to end this talk. So look, for decades, there was talk about an international court for the environment that never really took off the ground, but just the discussion around it was useful. I think, you know, in the near future, it's unlikely we'll see an international court for climate, but the cases are being brought before the ICC, the ICJ, the Inter-American Court. So for the time being, I think it's using the existing systems. Maybe in the future, you know, you're young, you might still see that international courts on climate emerge. It is definitely a problem that is going to persist. So I don't think we'll solve climate change before, and there might be one day an international court for that.
Thank you.
Thank you so much, Dr. Setzer. I'm going to cut it off now, but there are more questions. Maybe if you all send the questions to the Civic Ecology at cornell.edu email, if Dr. Setzer was so nice, I could forward them to her, and maybe we can post them in our WhatsApp group or in the next email we send out. But thank you so much. This was like super helpful and fascinating. And yeah, let's give a round of applause if you want to unmute yourself for Dr. Setzer. And if you are, yeah, thanks so much. And if you are Chinese speaking and would like to have another half hour, right, Fish? I don't know if you want, then you can stay. Fish will be facilitating that. If you don't speak Chinese, then you probably want to leave the recording right now because you won't be able to understand what we're saying. So,
thank you so much, Joanna. Fascinating.
Fish, we can't really hear you.
No, sorry.
Thank you, Fish. Thank you, Marianne. Thank you, everyone, for your attendance and for your questions. And I'm around. Hope to see you on the 27th of June.
Thank you so much, Joanna.
I posted the link. Thank
Great.
you.
Thank you. Bye-bye.
Bye.
Okay. Can you guys hear me now, Marianne?
Yeah. So
okay,
I
great.
will mute you, and just so that I don't hear you. And yeah, I'm not gonna. I just want to make sure I don't end the call for everybody. So I'll just mute you. So go ahead, but I'll stay on.
I see.
Okay.
I think you can also give me the host, and then you can just leave if you can do that.
Okay. Let me see.
Don't worry about it
host.
if you can. Right.
Okay. So Fish, does this work for you now?
Let me see. Yeah, I think it's now me, the host. So I think you can go. Don't worry about it.
Okay. Okay. Thanks so much, Fish. And thanks everybody who attended. So
thanks, Marianne. That was really great.
Starting in Chinese now. Yeah, it was really great. See ya. Bye.
See ya. 好，谢谢大家。我们